everyone. I am trying a new way of doing a Facebook Live video. So give me just 1 second here. I'm going to double check with my partner in crime to see if it is working. Oh, looks like it's just working now. All right, everyone, give me just a second here. We're going to check to make sure it's working and that it's showing up. Okay, looks like we're good. All right, so what a long day. Good evening, everyone. I was at the Nuevo Freedom Festival all day today, so I don't think we got home until, I want to say it was close to 8 o'clock. And of course, by then I had quite a few messages about people wanting to know what's going on in the court case between the legislature and the governor. So, like I said at the very beginning, this is a new way of doing Facebook Live for me, so we're going to try to see if it's going to work out for me to be able to watch all the comments and answer questions for people as they go along. But before I answer any questions, I'm going to go ahead and let you know I don't actually have a copy of a paper order from the court. I did reach out and email them, and I'm hoping that I'll be able to get a copy so I can write a brief for the next round of litigation on the matter, as well as to share with you, the public, what it said word for word. What I can tell you is what is on the court's docket sheet. It's typically called the Register of Actions in Michigan courts. So it's going to just have a listing of every single fee that was paid, every single document that was filed. And so what it has there is that today, in the latter part of the day, there's an opinion and order. It is hereby ordered that the relief requested in plaintiff's motion, that was the legislature, plaintiff's motion for immediate declaratory judgment is denied, while the governor's action of re-declaring the same emergency violated the provisions of the Emergency Management Act, plaintiff's challenges to the Emergency Powers of Governor Act, and the governor's authority to issue executive orders thereunder are meritless. This order resolves the last pending claim and closes the case. So, I haven't seen anything official come from either side. I don't know if anybody's released anything. I've seen that there's some articles out there, but I haven't seen anything official that comes from either the legislature or the governor's office. But what I can tell you is that some of these articles are talking about how it's just going to go right to the Supreme Court and essentially acting like we're bypassing the Court of Appeals. So I wanted to bring your guys' attention to some court rules. So Rule 7.203 deals with the jurisdiction of the Court of Appeals. And in there, it discusses that a party would have the ability to appeal of right, meaning there's essentially two different kinds of appeals. One is you have the absolute right to appeal if you lost at the level below. The other is you don't have a right to do that, but you could still ask for permission to be able to appeal. So they would have, the legislature would have the ability to appeal as of right a final judgment or final order of the circuit court, court of claims, circuit court or court of claims as defined in Rule 7.2026. And so it gives some exceptions. But essentially what this is saying is that Rule 7.203A1 says that because this was a final order of the Court of Claims, the legislature has the right to appeal to the Court of Appeals. As far as heading to the Supreme Court, that would take us to Michigan Court Rule 7.303. So the first one is 7.203. This is 7.303. And it is talking about the jurisdiction of the Supreme Court. So there's very few cases that the Michigan Supreme Court has mandatory review, meaning when someone wants to appeal, having lost at a level below, that the Supreme Court is bound to hear that case. Most of the time, the Supreme Court in Michigan gets to decide whether they're even going to take on a case. So, in fact, Rule 7.303, Jurisdiction of the Supreme Court, says that, and this is subdivision B, discretionary review, the Supreme Court may, subdivision 1, review by appeal a case pending in the Court of Appeals or after a decision by the Court of Appeals. So essentially what the legislature might do, and I thought I had heard the legislature's attorney talking about doing this, but I might be mixing it up with an attorney from a different case that's also suing the governor. But I believe what they're planning on doing is going ahead and filing their claim with the Court of Appeals and then requesting the Supreme Court to bypass the Court of Appeals and allow the claim to be heard right away in the Supreme Court. So one thing to consider is that when you do that, you have to file an application for leave to appeal. That's what it's called. And that's Rule 7.305. And subdivision B of that rule lays out the grounds, the things that the legislature's attorney is going to have to identify as reasons why the Supreme Court should take the case. So the application must show, and then there's a bunch of different factors. Some attorneys would argue factor 1, the issue involves a substantial question about the validity of a legislative act. Some would argue that would be involved, but I doubt that they would do that because I just don't see the legislature saying there's anything wrong with the laws that the legislature in the past has enacted. And so there's several provisions here, but in subdivision B4, it says, in an appeal before a decision of the Court of Appeals, where A delay in final adjudication is likely to cause substantial harm, or B, the appeal is from a ruling that a provision of the Michigan Constitution, a Michigan statute, a rule or regulation included in the Michigan Administrative Code, or any other action of the legislative or executive branch of state government is invalid. I know it's a bunch of legal jargon, but essentially, potentially we could be saying Michigan statute is invalid as it's written. The legislature is actually arguing, though, that the Michigan statute is not invalid as it's written. They're saying it's invalid as to how the governor chose to misapply it. So essentially what they would be saying there would fall under, again, this is Michigan Court Rule 7.305 B4B, that the appeal, they're appealing a ruling that an action of the executive branch is invalid. So anyway, that is my assumption. That's the only way they can get to the Supreme Court right now. Otherwise, they would have to just follow the usual route through the Court of Appeals. And then my assumption with that is either way, they're going to be asking the court to take this case on very quickly so that it gets resolved, because obviously this is impacting nearly 10 million people. And it's infringing upon our very constitutional rights. So it's urgent. But something we also need to keep in mind is that, like I said at the beginning, the Supreme Court, one second, child, get your feet off the table. People are going to get dizzy seeing me shake. Thank you. The Supreme Court only has to take the ones that are I think what did I say? It's called mandatory review. And so that's Court Rule 7.303A, and that is not what we're talking about. Everything that we'd be talking about is 7.303B, which is discretionary review. So whether the legislature's attorney files the case with the Court of Appeals and then allows it to just take its normal course through there, and then one of the two parties appeals to the Supreme Court, or whether the legislature's attorney files with the Court of Appeals and then asks the Supreme Court to immediately intervene and take the case away from the Court of Appeals, so we skip that whole step. Either way, the Supreme Court could decide that they just don't want to take the case. So I would urge each of you to make sure that you are having your voice heard. You are calling your state rep, calling your senator, calling the Attorney General's office, calling the governor's office, calling the Supreme Court office, calling the Court of Appeals office, that you are emailing all of them, that you are emailing and calling your local prosecuting attorneys and your local law enforcement agencies and letting them know that this issue is serious, that it needs to be handled immediately, and that you expect each and every one of those individuals to follow the law as it is written and follow the Constitution of the United States and the Constitution of the state of Michigan. And don't for a second let anyone tell you that you're too stupid to read those documents. You are not. I've been teaching my kids those documents for years. I believe in you. I don't care if you're an attorney, a doctor, a teacher, the trash collector, a dental hygienist, a car wash guy, a mechanic, or a machinist. You can read those documents. And if you are illiterate and you need somebody to help walk you through those documents, please ask. If I'm around, I'll help you. You need to know what's in the Michigan Constitution, and you need to know what's in the United States Constitution. You need to know that those documents are not just old pieces of paper, that those provisions just don't matter anymore. Those documents were crafted, well, especially the United States Constitution was crafted during a time of emergency. The whole Declaration of Independence was born through an emergency. An emergency does not take away our rights. I see I already have questions, so I'm going to go to these, and then I have more law I can share with you on that point. Does the court consider time is of the essence? Well, like I said, my assumption is that when the legislature's attorney is going to file the appeal, he is going to probably ask for, what would it be at this stage? Essentially, he's going to ask for immediate review. It's still up to the court to determine whether they're going to grant that request for that immediate review. My assumption is that they would probably do that, given the nature of everything, but there is no guarantee. So, does the court consider that time is of the essence here? I don't know. I hope so. Where do we get the book of the court rules? Mike, can you go to the, open another window, and then one of my links at the top where it says court rules, one of my favorites. What is the website there?
Courts.michigan.gov.
Courts.michigan.gov would be where the court rules are. Can you scroll to the top? Oh, that looks all goofy. Okay, and then does it say under courts, does it say court rules? My contacts are like totally expired, so I can't really read it, but you should be able to go, even if you just did a Google search and you searched on Google for Michigan Court Rules. It should be able to pop up. I've done that many times before. But if you search for Michigan Court Rules, Chapter 7 is, hey Mike, can you hand me this older book, the 2015? So, like I said, I've been doing all of this work for free. I've had some people pay for some gas money for me to get up north to give some information to people and things like that. But at any rate, most of the work that I've done in the last few years and beyond has been on a pro bono nature. So what I have here is actually the 2015 Rules of Court. That's my newest paper copy version. Otherwise, I go to the online version. At any rate, though, it's the same set. So hopefully you guys, you probably can't see this. Anyway, Chapter 1 is general provisions. Chapter 2 is civil procedure. Get your feet off my desk. Thank you. Off my desk. Thank you. Chapter 3 is special proceedings and actions. Chapter 4, district court. Typically like where misdemeanors are handled and landlord-tenant situations. That's going to be there. Chapter 5 is probate court. Chapter 6 is criminal procedure. Chapter 7 is appellate rules. So it's in there. There's also additional pieces in here, but Chapter 7, the appellate rules, is what I'm talking about. And so we were talking about Rule 7.203 and 7.303 and 7.305. So hopefully that answers that question. While my husband is feverishly writing down the next couple questions here, I wanted to see if I could very quickly find for you. Here's just some Michigan law on point. I do believe this is Michigan. Yep. This was in the Court of Appeals of Michigan, September 2011. And in it, they're quoting Michigan Court of Appeals cases as well as, I guess I'm just trying to read here. I don't know if they're actually quoting Supreme Court cases of Michigan, but they're talking about this concept of these two statutes, right? The Emergency Management Act and the Emergency Powers of Governor Act. And essentially what this two-sentence or one-sentence order of the court said is, well, yeah, the governor violated the Emergency Management Act, but she didn't violate the Emergency Powers of Governor Act. They have to be read together. That's how our laws work. So here we go. Statutes that relate to the same subject matter or share a common purpose are in pari materia and must be read together as one law to effectuate the legislative purpose as found in harmonious statutes. This is from the Michigan Court of Appeals in 2011. And they were citing a 2009 case. Also, if two statutes lend themselves to a construction that avoids conflict, that construction should control. So in other words, if we're saying, well, the 1976 Act requires a time frame, the 1945 Act does not require a time frame, so they have to be read together. And if we're able to read them together in a way that just says one is more specific than the other, then we're saying we can read them in a way that they're not in conflict. What the governor is arguing, what the attorney general is arguing, and apparently what the Court of Claims judge says, is that we're to assume that the statutes are in conflict because one statute says you have a time limit, governor, and the other one says no, you don't. It's actually not what the 1945 Act says at all. It doesn't say she doesn't have a time limit. It just doesn't talk about that subject. At any rate, then the Court of Appeals in this case quotes a different 2007 Court of Appeals case that says when two statutes are in pari materia but conflict with one another on a particular issue, the more specific statute must control over the more generic statute, which is really funny because I've actually been talking about that for quite some time and could not, for the life of me, find where that is in our case law. And voila, it's actually here. Also, then they cited different, 1999 Michigan Court of Appeals case, that the rules of statutory construction also provide that a more recently enacted law has precedence over the older statute. So the 1976 statute would take precedence over the 1945, and they're saying the more specific 1976 statute would control over the more general statute, 1945. So this rule is particularly persuasive when one statute is both the more specific and the more recent, hence the Emergency Management Act. Mind you, the more general, older act is literally defining the governor's powers because it is within the whole provision, Chapter 10 of our laws, that talk about all of the governor's powers in general. Does it describe every single way that her powers are limited? Nope. Doesn't mean that they're not limited, because then we would have a monarchy or a dictatorship, which we don't. At any rate, there's another set of important provisions. So there's another court case. This one is from, the Michigan Supreme Court from 1936. So it's been around for a long time. They should know better. It is the rule that where two laws are in paramateria, are in irreconcilable conflict, the one last enacted will control or be regarded as an exception to or qualification of the prior statute. So to the extent that the governor and the attorney general are arguing that the 1945 Act says she doesn't have a time requirement, but the 1976 Act says she does, this from 1936 says, well, but the more recent enacted statute would control, and it would act at least as a qualification of the older statute. Yeah, that's actually what I've been saying all along. Kind of funny. I just use common sense, but there you go. That's actually from the Michigan Supreme Court from the 1930s. And then in this case, from the Court of Appeals from 2007, they actually go into basic all those things, all those concepts I just talked about. They just continue to cite yet more cases that say the very same things. So I wasn't making this stuff up. Also, let's see. Yep, that's not exactly what I wanted to share. Mike, are there more questions right now?
Yes, there are. I have some trouble right here.
You're having troubles? Okay. Why does Attorney General Nessel keep stating face masks are a law? Because she's breaking the law. Attorney General Nessel and the governor of the state of Michigan and every single law enforcement officer and prosecuting attorney and public health official and local government official who is trying to enforce any single one of these executive orders at this point, now that we're past April 30th, there is zero way to argue that they have any legal force and effect at all. So the fact that Attorney General Nessel keeps arguing that face masks are the law, I don't know why, because she's violating her oath of office. She took an oath to uphold the U.S. and Michigan constitutions, and she is violating that oath. And I'm not going to stand for being bullied by an attorney general who knows better. You shouldn't be either. This is ridiculous. We have to take a stand. It's been a long day. Sorry that I'm yelling at you guys. Can we hold the respective Chamber of Commerces responsible at all? You know, that's a good question. What I don't like is how we have organizations like a Business Chamber of Commerce or, what would be another? They're not governmental agencies, but essentially, you know, like insurance companies and other private organizations that are constantly conveying to the public that these executive orders are real and they're enforceable and we have to wear masks in public and we have to be socially distant and restaurants can't do dine-in service and movie theaters can't be open and all the rest of the garbage. It's all garbage. The emergency powers ended on April 30th. Even if you think they are entirely constitutional on their face, they still ended April 30th. So not a single one of those requirements are legally enforceable. Not a single one of those emergency power executive orders are enforceable, except I think it was possibly executive order 2020-94 was the one where she declared a state of emergency for, I don't know if it was the city of Midland or Midland County due to the flooding. That executive order I could see would need to be in place because there's an actual emergency. There's flooding. And we definitely need to engage in our supports and services to make sure that my family members who live in Midland are, they're being cared for. Quite honestly, well, I'm not going to comment on something I haven't seen the documents for. I'll be doing a Facebook Live video about that and the cause of that as soon as I get the documentation to back it up. I like to base my arguments and my statements on the truth and on the law. So I will make sure I see the actual physical documents before I address those issues. So at any rate, we do need to hold the chambers of commerce, hold the insurance companies, hold all of these other organizations that are passing along this misinformation, these lies. They should be held accountable. What does that look like? I don't know. But it doesn't matter to me if those organizations don't have attorneys on staff or if they do. It doesn't matter. We're all citizens. We all know that ignorance of the law is no excuse, right? If you get pulled over and the cop says, oh, well, you know, you were going 60 miles an hour and the speed limit here is 45, and you said, oh, well, I didn't know that. I didn't see the speed limit sign. What are they going to say? Oh, you didn't see it? I'm so sorry. I can't write you a ticket then. No. Ignorance of the law is no excuse. Well, guess what? That works for all of us. So those people that are out there telling people that they can't open their businesses and that they have to wear masks in public and they have to follow all of these executive orders, they're part of the problem. Help me. Educate them. Give them a pocket constitution. Send them the link to the Michigan Legislature website that lists our Michigan Constitution. Share some of the videos or the documents that I've been posting on my Facebook page or stopcovidchaos.com so we can educate people. Let's get educated. We've been in the dark for way too long. My husband is feverishly trying to write out some of the questions that you guys have, so give him just a second to try to do that. In the meantime, here's just some, I don't know, some things I thought that might be helpful from the Michigan Court of Appeals. Let's see. This one is from the Michigan Supreme Court from 1982. When the legislative and executive powers are united in the same person or body, there can be no liberty. Because apprehensions may arise, lest the same monarch should enact tyrannical laws to execute them in a tyrannical manner. So, when the legislative and executive powers are united in the same person, there can be no liberty. Those aren't my words. I totally agree. That is something that the Michigan Supreme Court said in 1982. Guess what happens now? Guess what happens when we have the situation where a governor is telling us, I am emergency power queen, and I'm going to issue all these executive orders, and you just have to follow them because you're my peasants. That is when the executive powers and the legislative powers are merged into one person, and guess what? We now have no liberty. That is the whole reason why we have the separation of powers. That is the whole reason why our Constitution, the state Constitution, Article 3, Section 2, says that no person who's exercising the powers of one branch of government can also exercise the powers of another branch of government. Very clear words. It doesn't say except when there's an emergency. Duh, because she needs to write these emergency executive orders. Nope. Because when you unite those two powers in the same person, there can be no liberty. Oh, look at this case actually talks about Article 3, Section 2 of the Constitution. All right. Oh, wait, this is interesting. I believe this is a U.S. Supreme Court case. It is indeed a 1934 U.S. Supreme Court case. So at this point in the analysis, they say we must consider the relation of emergency to constitutional power. Seems relevant. Word for word, what it says here. Emergency does not create power. Emergency does not increase granted power or remove or diminish the restrictions imposed upon granted power, granted or reserved. Notice it's not saying anything about our individual liberties are allowed to be curtailed or we're allowed to be put on house arrest or lockdown orders or stay at home, stay safe, whatever they're calling it. It is literally talking about the powers of the government. Emergency does not create power, and emergency does not increase granted power. So the powers you already get as a governor or a legislature under the Constitution do not increase simply because there is an emergency. Also, the emergency does not remove or diminish the restrictions imposed upon power granted or reserved. So you might have this exercise of a certain power under the Constitution, but there's a provision that yanks it back in and requires there to be some sort of check and balance system. An emergency does not take away that check and balance system. The Constitution was adopted in a period of grave emergency. Its grants of power to the federal government and its limitations of the power of the states were determined in the light of emergency, and they are not altered by emergency. I don't know about you. Maybe it's just because I'm an attorney. That seems to be very clear here. Our Constitution doesn't get to be modified or erased. It wasn't written in pencil. You can't just come along with an eraser and then change the parts that you don't like. Oh, here's a good one, because people have been asking about, well, why can't we have laws that go against the Constitution? I mean, that's okay. Our legislature enacted them, except for this concept right here. A law repugnant to the Constitution is void. And courts, as well as other departments, like attorney generals or health departments, are bound by that instrument, the Constitution. And this is a case from the Michigan Supreme Court from 2004. The legislative powers, the power to determine the interests of the public, to formulate legislative policy, and to create, alter, and repeal laws. The governor has no power to make laws. The executive branch may only apply the policy so fixed and determined by the legislative branch, and may not itself determine matters of public policy or change the policy laid down by the legislature. There are several other extremely important cases that I will definitely be telling you all about. Oh, yes, this is actually the one I was looking for. This case came from the Supreme Court of Michigan in 1865. The Constitution has proved to be as well adapted to the present exigencies as to those of the early days of the Republic. But it may easily happen that specific provisions may, in unforeseen emergencies, turn out to have been inexpedient. This does not make these provisions any less binding. Constitutions cannot be changed by events alone. They remain as the acts of the people in their sovereign capacity as the framers of the government until they are amended or abrogated by the action prescribed by the authority which created them. Emergencies don't create constitutional changes. Proper constitutional amendment actions create constitutional changes. Can we hold the judge accountable for not following the Constitution as written? Is this still part of the same question? Is it the same person?
Not exactly.
Okay, so I'm going to just stop reading. I thought it was all part of the same question. So, can we hold the judge accountable? Every single person who works in government, every single public official, every single law enforcement officer, every single attorney in the state of Michigan, every single judge, school board member, city council member, township trustee, every single one of them, under the Michigan Constitution, Article 11, Section 1, swears an oath to uphold the U.S. and Michigan constitutions. And so, when they clearly violate that oath, there are problems. In fact, I guess to specifically answer the question, I have mentioned before that all of these government officials who are attempting to enforce these obviously illegal executive orders, that they are engaging in malicious prosecution, they are engaging in abuse of process, and they're stepping outside of the bounds of their governmental authority. In addition to that, couple things here. Some federal laws come into play. The other ones I mentioned, the malicious prosecution, the abuse of process, those are state laws. But federal laws, we have 18 U.S.C. Section 241, conspiracy against rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state in the free exercise or enjoyment of any right or privilege secured to him by the Constitution, they shall be fined under this title or imprisoned not more than 10 years or both. Fined or 10 years imprisonment or both. Additionally, there were a lot of people that have been coming to me even today after being in Newaygo and speaking there. People approached me about family members dying from various things due to COVID-19 restrictions here in Michigan. So whether it's not being able to get adequate medical care because it was deemed non-essential, and then the family member has since passed away, or the family member or friend succumbed to anxiety or depression or some other sort of mental health disorder because they were cut off from their church, cut off from their work, cut off from their family, cut off from their community and their neighborhood, cut off from their counseling and their group therapy or whatever the case may be. And so they finally succeeded in a suicide attempt. Or they're in a nursing home and they are being not cared for because of all these provisions. Family members can't even go and check in on them to see if they're okay. Can't lay eyes on them. For all those people, I'm going to tell you that the rest of this federal law says that if deaths result from the acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, like say in the nursing homes, they shall be fined, meaning the person doing this, under this title or imprisoned for any term of years or for life, or may be sentenced to death. Seems pretty serious to me. And that wasn't even the framers that put that in there. I believe that was enacted in 1996, so that would be, 96. I want to say that was Bill Clinton. I want to say Bill Clinton signed this into law, and of course that would have been the 418 or whatever representatives in the U.S. House and the 100 senators that were involved in this. I don't know if this was a unanimous vote or whatnot, but it became law. So all of those people. And at this point, I would think it's a pretty good argument to say that there's a conspiracy. There's a conspiracy to deprive people of their rights guaranteed by the Constitution. So, I mean, at the very least, we have a governor and an attorney general and the local law enforcement agencies. So, yeah. So to answer your question, there's that. And 42 USC section 1983. Every person who, under the color of any statute, meaning they're claiming they have the legal authority to do that, but they don't, of any state, subjects or causes to be subjected any citizen of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. So the first one makes it a crime. The second one gives civil, the ability to pursue civilly. So, okay. So the quick recap that I guess we have needed because people are just signing on. I'm going to ask you to please go back to the beginning when it's all done and hear the in detail version. But basically, the Court of Claims judge, hey, you're shaking my camera, dude. The Court of Claims judge ruled that the legislature does not win this round, and that although the governor violated the Emergency Management Act of 1976, that somehow she did not violate the Emergency Powers Act. And so I had been reading several different cases that clearly articulate how the two laws have to be read together. If there's any kind of conflict at all, which I don't think there even is, but if there is a conflict, they're supposed to look at the more recent law, and they're supposed to look at the one that's more specific, especially if the new law is the one that's more specific, which clearly the 1976 Act is the one that has the 28-day provision in there. So I don't see how there is any way around that whatsoever. Another interesting thing is MCL, Michigan Codified Law, our statutes, 8.8, says that a law is A, a public act of the legislature, B, an initiated law adopted by the people, or C, an executive order of the governor submitted to the legislature pursuant to Section 2, Article 5 of the state constitution and having the force of law. I'm just going to fast forward and say, until you get out your state constitution and read Article 5, Section 2, the governor did not submit it to the legislature, and there was not a period of time that the legislature had to, in order to vote to disapprove of these executive orders. So clearly, what she's doing is not law. It does not have the force and effect of law. Interestingly enough, I do want to point out as well, in our very Declaration of Independence, for those of you who might be wondering, why is this all a big deal? Well, hopefully all the other things I told you explain why it's a big deal. But in our Declaration of Independence, it says they are declaring independence because their legislatures were suspended, and instead those ruling were declaring themselves invested with power to legislate for them, which is exactly what the governor is trying to do here when she is trying to say that her executive orders have the force and effect of law, and so therefore law enforcement can come out and write you tickets, and therefore if you're opening your restaurant in violation of these orders, the health department can supposedly come and issue you citations and take away your license or your liquor license or what have you. If you're cutting hair, you're not allowed to do that, according to them. It violates these executive orders, and because they're law, they're going to pull your barber's license or your cosmetology license. I just read to you what qualifies as law. Executive orders like this, not one of them. Emergency powers of the of the executive branch do not exist in our Constitution, and that is the very power, that is the very exercise of legislative power done by an executive that caused our founding fathers to pull away from the crown and declare independence in the Declaration of Independence. So this is serious stuff. This isn't about wearing a mask for a few minutes every time you walk into a store for the next couple weeks. First of all, Gretchen Whitmer's not going to stop in a couple weeks. Dr. Janae Khaldun said in a recent press conference, at more than one, that this is just the beginning of fighting this whole big thing, and we should really be basically shut down and doing all these procedures to keep everyone safe, at least until the end of the year. But even if it was for one day, our Constitution does not allow that. Your Constitution does not allow your rights to be stripped away for even one day, let alone for 9 weeks. You are guaranteed that freedom. We're celebrating Memorial Day weekend. We're celebrating all of those people who fought for our country and fought to protect our rights to the very freedoms secured in the Constitution. How is that not spitting on the graves of every single one of those fallen men and women who gave all to protect our freedoms, when you just say, it's just temporary. Well, it's what the governor deems safe. Well, you should just make the sacrifice because there's other people that need our help and this is what will help them. No, the U.S. Department of Health and Human Services secretary said on Sunday to the public, hey, by the way, these stay-at-home orders are killing more people than COVID-19. Literally, that's what he said. The stay-at-home orders are killing more people than COVID-19. So if you disagree with him, you should take it up with him. You can also look at the studies done in Germany because, as you know, Europe got COVID-19 before we did. And they did extensive studies and determined that stay-at-home orders do not stop the spread of COVID-19, and they do not decrease the risk of death. In fact, if you look at the studies that were just done in New York, they just had this huge second surge, if you will, all in like a concentrated area, I do believe. And of the like almost 1,400 new cases of people that were admitted to the hospital because of COVID-19, 84% of them, let me see if I can find that information. 84% of them actually were under stay-at-home orders. So, oh, yep, here it is. So he said, Governor Cuomo, I think as I'm saying that right, everything is closed down. Overwhelmingly, the people are at home. The new patients who continue to show up to emergency rooms suffering from COVID-19 illness are mostly elderly people and mostly those who are retired or unemployed, who don't take the subway, who don't work in hospitals or otherwise expose themselves to the virus in any obvious way. People who have been under strict stay-at-home orders all along are getting this virus. They're not working. They're not traveling. This is the governor, the Democrat governor of the state of New York. They're not working. They're not traveling. They're predominantly downstate, predominantly minority, predominantly older, predominantly non-essential employees. So in other words, they've been staying at home because their business has been closed. 83% of the coronavirus patients are either retired or unemployed, and they've been at home. In fact, somebody was asking about them using public transportation. Only 4% of them, 4% of these new cases were using public transportation in any way. That's it, 4%. So let's think about what the data really shows. I mean, that's just a whole nother video. I just want you guys to have the facts. It's so disturbing that the government and the media are keeping the facts away from us. Those are government facts. I'm not getting my news from Fox News or CNN or Facebook. I'm getting my news from the government. Okay, we have a question. The Emergency Power of Governors Act does not state that the executive orders have the effect of law. The Emergency Management Act does, however. This ruling said Whitmer violated the EMA. Seems that this argument should have been brought up by the legislature's attorney and the constitutional provision. I guess I'm not sure exactly what the question is about the constitutional provision there. And I can pull up the statute. I do believe you're right about MCL 10.31, but I like to be 100% accurate when I am sharing this information with people. So 10.31 allows her to promulgate these orders, but I do believe that it is, let's see. Well, the thing is, it doesn't say in 10.31 that to address this question that was asked, it doesn't say in the Emergency Powers of Governor Act that they have the force and effect of law. However, if you go to 10.33, I believe it is. I have way too many statutes in front of me right now. But I believe it's 10.33. It actually says that a violation of the orders is punishable as a misdemeanor. So it does give the governor the ability to enforce these as though they're law. So at any rate, so that distinction isn't exactly either way. I don't think that reading either of these statutes that way, it just doesn't hold water. A lot of people want to know how we are going to get out of this. Will there be justice? There will only be justice if everyone stands up. I can't be the only attorney, the only person standing up and informing people. It's going to take every single person that I met today. I don't even know how many people there were at that thing, like 2,000. It's going to take every single person sharing the law, sharing the Constitution, sharing the facts with everyone they know. So everyone that's watching, go ahead and look at stopcovidchaos.com. I have quite a few of the statutes and cases listed on there. I will upload more as soon as I have my next brief drafted. Is it going to be long? Yeah, it is. And you're going to have to take the time. You're going to have to take the time to read it. Think about how many countless hours, hundreds, if not thousands. I can't do the math in my head right now. I've literally been working on this the whole month of April and the whole month of May. Like, it did not even occur to me that it was May until 2 days ago. I didn't even get to enjoy Mother's Day. I was working on this stuff on Mother's Day, and I have 4 kids. It's going to take your time. It's going to be something you have to make a priority. Read the Constitution. Read the state constitution, read the U.S. Constitution, and look at the documents that I've put out in front of you that pull all those details together, because I know when you're just looking at it all, it can seem very overwhelming. And sometimes, especially with our laws, there's stuff, the laws are so disorganized in so many different topics that it could be very overwhelming to try to look at them on your own and feel like you're understanding everything. Look at the summaries I've put together that help you pull the laws on the same subject from all those different areas together. But we can bring these people to justice. Absolutely. There are many provisions in our laws. There are provisions that I spoke about tonight. There's provisions that I've talked about before. There's things that will be yet to come that we'll talk about. But we can bring justice back. But everybody has to stick together. Don't expect your neighbor to do it. Don't expect the other barber shop to open up. Don't expect the restaurant across the street to open up before you open up your restaurant. We all have to stick together. If you know in your heart that your church should be open right now, because quite frankly, the governor's executive order doesn't even stop us as churches from opening. If you know you should be opening and your church isn't open, please be looking for a church that is open. We got to be the hands and feet of Jesus here. We have to be educating people on what the law is. So it's going to take all of us. It doesn't matter if you don't have a law license. I'm not asking you to practice law. I'm asking you to share the Constitution with people. I'm asking you to share the information. You give them the information. You tell them about the website or about my Facebook page. You tell them to email or call me if they've read it and they just don't understand something. I have been answering every single question that I get. Sometimes it takes a little bit longer than others. But we do have another question here. Well, first I had this one. Can she violate one statute with no consequences, but then it's okay because of the other statute? That's why. Okay, so I'm going to repeat the question. So basically, can the governor violate one statute, but then have no consequences because it's okay under another statute? No, that's actually not okay. I mean, that's what the judge said, essentially. But no, it's not okay. That's why all these other cases have totally explained why we read our laws together. We can't look at a law and say, well, I'm going to cherry pick. I'm going to go and follow this one, but not this one. Oh, you know what? You guys would love to hear what I actually discovered last night. Give me just 1 second before I address this next question. You're going to love this. Okay. So right on the legislature's website, it actually says, it demonstrates every single, or shows you every single executive order that has been issued in the state of Michigan from 1993, I believe, forward. Okay? So from 1993 to the present, so far here in Michigan this year in 2020, I believe we're at 97 executive orders, unless she's issued more and I just don't know about them yet. In 2019, Governor Whitmer herself issued 7 emergency executive orders, declaring either a state of disaster or state of emergency. In every single one of those, she only references the Emergency Management Act. Somehow as though that is the primary mechanism for her utilizing these powers, like as though the Emergency Powers of Governor Act was just the beginning point of those powers, but now there's this newer statute that puts more teeth to it. She also, in every single one of those, mentions the 28-day time limit. There is one where she mentions that it's only going to be in place for 4 days, I believe. But all the other ones, she specifically says that she cannot extend that state of emergency on her own unless she follows the procedures of the Emergency Management Act. Interesting. Also, between 2011 and 2018, there were zero executive orders declaring a state of emergency or state of disaster by any of the governors we had during that time in Michigan. 2010, there were 2 states of emergency declared. And guess what? Only the Emergency Management Act was referred to as the primary source of this authority. And it said right in there that that emergency could not go beyond the 28 days without legislative approval. In 2009, we had 1 state of emergency declared, and only the Emergency Management Act was stated as the source of that power. And it didn't have the 28-day time frame, but it specifically said the state of emergency was only meant to repair the road. I want to say it was I-75, and it was after an explosion. But it was not, in an entire community, and it was not for a period of time other than to just simply fix the road. That was it. 2008, we had 10 states of emergency or states of disaster declared. And every single one of those, and I believe that was Jennifer Granholm, only the Emergency Management Act was used to provide reference for that power. And in every single one of those, it specifically stated it would have to expire by the 28th day unless the legislature gave additional time. 2007, there were 2. Same thing. The Emergency Management Act was the one that was mentioned, not the Emergency Powers of Governor Act. And the 28-day time frame was referenced. In 2006, there were 2. And the Emergency Management Act was the only one mentioned. And the 28-day time frame was in there. 2005, 1 was issued. And guess what? The Emergency Management Act was the only one cited for the source of that authority. And the 28-day time frame was also in there. And there were no, let's see, there were no executive orders that declared a state of emergency or state of disaster between 1993 and 2005 in the state of Michigan. None. So, one thing that's important to note, I want to clarify that in 2010, Executive Order 2010-7 did reference the Emergency Powers of Governor Act at the top along with the Emergency Management Act. But at the bottom, when it comes to citing the authority, where they say, I, as the governor of the state of Michigan, under the powers vested in me in the Michigan Constitution, under this provision, and the laws of the state of Michigan, specifically the Emergency Management Act, in that provision, they didn't bring up the Emergency Powers of Governor Act, just the Emergency Management Act. So they acknowledge at the top in that one order of all these that there is an Emergency Power of Governor Act, but state later on that is not what the source of the power is for declaring these states of emergency. And some of these were localized, some of these were statewide. They covered everything from winter weather to flooding, an oil pipeline spill, severe storms, an explosion, wildfire, excessive rainfall, even Hurricane Katrina assistance. So just something that I thought you guys might want to know about the history of our use here and how it has never been something where the governor, at least since 1976, where a governor in the state of Michigan has said, guess what? I'm just going to go ahead and give myself unlimited powers under the Emergency Powers of Governor Act from 1945 and totally ignore the 1976 statute. It's never happened except for Whitmer, which she didn't even do in all of her emergencies that she declared in 2019. If the governor breaks one of her own orders, can we, the people, fine her the same $1,000 citation for disorderly conduct that she fined the hairstylist at the Capitol? How can I get that done? So here's the deal. First of all, we can't legally, if any of you are receiving these citations, if you're receiving, the $1,000 is like civil infraction type of ticket, or you have been given a criminal misdemeanor ticket, which could mean that you're facing up to 90 days in jail or a $500 fine. We need to fight these because there is no basis in law for any of these being issued, certainly not after April 30th. But what's even more important is that the $1,000 civil infraction and the licensing violations come out of April 2nd, a series of two emergency orders issued on April 2nd by the director of the Department of Health and Human Services here in Michigan. The second order, Governor Whitmer signed in concurrence with the findings of the director of the Department of Health and Human Services, but he essentially said in there that if you violate these executive orders, or you even violate the frequently asked questions portion of the Michigan.gov website, that you can then be held responsible not only criminally, but for these civil infractions for $1,000 and for these licensing consequences. That's not acceptable for a variety of reasons, but one of the most easy reasons to understand is that the law specifically prescribes what the punishment for a violation would be. So even if the misdemeanor was allowed, the civil infraction is not allowed. The legislature was very clear in both the 1945 Act and the 1976 Act, very clear in stating that if you were punished for this, if you were guilty of violating one of these executive orders, the most you can be punished is for the misdemeanor, 90 days in jail, $500 fine. So that's what the law says. So again, the governor can't create law. Even if we're going to want to argue that these executive orders have legal authority up until April 30th, they didn't have authority. The governor couldn't do it, and certainly not the director of the Department of Health and Human Services here in Michigan did not have the authority to say, well, if you violate these executive orders, or even the frequently asked questions section of the Michigan.gov website, we're going to issue a citation for $1,000 for each occurrence, or each day or each occurrence. Basically, they want to be able to write as many tickets to you as they can, and we're going to give you licensing consequences. That's not okay. The legislature never put that in place. They can't just issue crimes and create crimes like that. That's not how our laws work. If you think it's confusing, it's because it is, because it's not allowed. Our system is very clear. The legislature creates the laws, the governor enforces them, and the court is there to sort it all out. But every single one of those branches has the duty, not the option, the duty to enforce the Supreme Court, the supreme law of the land, the Constitution of the United States, and the Constitution of the state of Michigan. Every single one of those branches. And one branch does not get to exercise the powers of another branch. This was another question. Oops. She keeps saying that more people are getting it. I work in healthcare and we are testing more people, and the percentage of people testing positive are going down. Whitmer is using her made-up numbers as an excuse for her extensions of power. Can't we sue her for that information? Very good question. And actually, that is, my understanding is that is what one of the House resolutions was that passed. I want to say that was also the week of April 30th that the legislature passed a resolution to request the facts from the governor, because they, even as the legislature, as individual legislators, were being given a bunch of different information and sets of numbers from healthcare providers and from the Michigan Department of Health and Human Services and from the governor's office, and none of the numbers matched up, and they don't. If you go to stopcovidchaos.com, you'll be able to see there's a document called, I think it says CDC COVID-19 data, and you can look at how the data is misleading. Every single document in there is from the CDC. And I give you references to the URL so you can go to those websites yourself. Please do. Please check it out. The numbers are not what they say they are. And every single healthcare provider that I have actually spoken to has said things like, well, we had another patient die of COVID-19. I mean, he was in a car accident and we didn't even test him for COVID-19, but he might have had it, so we're going to label him as COVID-19. An individual today was telling me up in Nuevo that a family member died of cancer. And at least in that situation, the hospital was kind enough to ask the family, could we label this as COVID-19 even though the family member didn't have COVID-19? Seriously? And what was the other? Oh, yes. Where individuals have had a blood alcohol limit, a blood alcohol amount that was so high, they were, I don't remember the exact numbers, like 5 times the legal limit. And they died. But the hospital is going to label it as COVID-19. I think in that particular case that I'm thinking of, the patient actually might have tested positive for COVID-19, but clearly the death had nothing to do with COVID-19 because the guy just drank and drank and drank alcohol until his body could not function any longer. So we do know that the numbers are being messed with, and we need people to speak out all over the place. We need people like these healthcare providers to share this information. We need to get this information out there. We need the public to know about it because the media is not doing their job. They're not doing investigative journalism anymore. And the governor and every other aspect of our government right now is keeping that information away from us. Okay, so I answered that one, right? Is there any more? Let me see.
I think we're good.
Okay, so I think I've answered all of your questions. I've certainly been on here a lot longer than I wanted to be because now it is super late. But there's a court ruling to many of the partially wrong. Email addresses. I do believe I'm good on email. Can you? They're still coming. Can you read them? I do believe that I have email addresses, but let me tell you, if you can go and take that letter to prosecutors, if that's what it's called. I'm pretty sure that's what it's called. Anyway, if you go to the stopcovidchaos.com website and you pull that letter and you print it off or want to save it as a PDF and email it yourself, please do make sure you are getting it to every single law enforcement officer that you know and every single prosecuting attorney and city attorney. Could you imagine if every single, if even one in 100 people in a community brought that information to the law enforcement officers in the community? They're going to have to start waking up. They're going to have to realize people are going to hold them accountable. But it takes just one, right? It's going to take you. And it's going to take you. And all of you are going to have to individually do it. And don't feel like you're alone. You're not alone. Don't feel like you can't do anything. You can. We need you. I can't do anything on my own. I mean, I have God. God's been helping me a lot. God's been giving me a platform I never thought I would want or need. But certainly I'm not doing this alone. But I can't do this on my own. It's going to take all of us. It doesn't matter if you are a stay-at-home mom or if you're a super high-powered exec somewhere. It doesn't matter if you're poor or you're rich or you live in Detroit or you live in the UP. We need to stick together. We need to educate our law enforcement. We need to educate our local judges. We need to educate our school board members. We need to educate every single person who works in government who has sworn an oath to uphold the U.S. and Michigan constitutions, what their job is. We need to remind them of that. Even if they took that oath years ago, we need to remind them. So please help us do that. It's not about a personal attack. It's about reminding them of that oath and that they are not alone. They are not alone. You are there to support them in choosing the right thing. Are we good? Do we have any other questions? Oh, did you give me a question? Which one? This?
Yeah.
Will this go to the, when will this go to the Supreme Court? Well, it depends on which Supreme Court you're talking about. So what I can tell you is that at the very beginning, I kind of went into a bunch of detail about Michigan Court Rule 7.203 and 7.303. And the law, the court rule on point, says that the legislature has the right to file an appeal with the Michigan Court of Appeals. However, they can try to bypass the Court of Appeals. They have to file the documents there. And before the Court of Appeals rules, they can request the Supreme Court to take the case, the Michigan Supreme Court to take the case. But the Michigan Supreme Court gets to decide whether they're going to do that or not. Even if the legislature lets the whole case go through just at the Michigan Court of Appeals level, the Michigan Supreme Court can decide they're not even going to take the case, even if it makes it that way naturally. So we need to put the pressure on. We need to let the judges know. We need to let the justices know. We need to let everyone in government know we're watching you, and you need to start following the Constitution of the United States and the Constitution of the state of Michigan. And we will hold you accountable if you're choosing to take the easy way out and just follow this monarch, or the oligarchy, I guess it would be. Which one?
You are green.
Interesting. I'm putting my conservative beliefs before the Constitution. How is that possible? Exactly what does that mean? Whoever wrote that, please tell me exactly what that means. Please tell me what constitutional provision allows any of this to happen. Please tell me what constitutional provision allows an executive branch person, the governor, to exercise legislative powers, i.e. writing new laws or executive orders that she wants to be legally enforceable, like a law. Or what would allow a judge or a prosecuting attorney or local law enforcement, what allows any of them to enforce this when it does not follow the statute and it does not follow the Constitution? Seriously, I will totally answer that, but I can't answer argument. I mean, this is just argument and there's nothing behind it. So the comment was, you are putting your conservative beliefs before the Constitution. No, I've actually read the Constitution. So whoever you are, have you read it? Have you read the state Constitution? Do you understand Article 3, Section 2 of our state Constitution? Because that is one of the most important pieces right here. Article 3, Section 2 of our state Constitution. This is not my conservative viewpoint. This is a plain English reading of the Constitution, drafted long before I was born. This is not my political viewpoint. These are the facts, and this is the law, okay? Separation of powers. The powers of government are divided into three branches: legislative, executive, and judicial. No person exercising powers of one branch shall exercise powers properly belonging to another branch, except as expressly provided in this Constitution. Not in a law written by a legislature later on. In this Constitution. So I'm serious. If you tell me exactly how you think I'm not reading the Constitution correct, I would love to know. Because even the attorneys, the snarky prosecuting attorneys that have responded to my letter to prosecutors that have said I'm threatening them and my opinion doesn't matter and everything else, and only a judge's opinion matters, they have not once been able to tell me exactly what is wrong with the legal analysis that I have sent to them. Not one of them. Interesting. But you don't get to walk around bullying people when you haven't even read the documents yourself. That's why people are afraid to stand up in the first place, and I am sick of it, and I am not going to let it happen anymore. Is that your comment? I thought I was going to answer another question, but no, it's just my husband giving me a thumbs up, basically. Listen, if you are watching this and you know it's wrong, but you feel like you just don't have the power, that you don't have that personality type, that you don't like conflict, that you don't want to make your family members or your friends mad, that you just don't feel like this is your correct stage in life to be taking up something like this. This is for your children. This is for your grandchildren. This is for your nieces and your nephews and all the little neighbor kids. This is for everyone you care about. Because if we don't stop this insanity, this blatant violation of our U.S. and Michigan constitutions and the statutes aren't even being followed. If we don't stand up together to stop this, it's not going to get any better. It's not going to go away in June or July or August. It's going to get worse. Because the second we give up some of these freedoms, they're going to go after the other ones. Like in the midst of this whole big thing, if COVID-19 is such this horrible deal that a lot of all of the Democrat legislators in the state of Michigan are so worried about, and we have to just give the governor all this power that she's not legally or constitutionally entitled to, I want to know why they would take the time to introduce gun control legislation that clearly violates the Second Amendment, along with other amendments, by the way, but other constitutional provisions, I should say. Why bother with that? If COVID-19 is so scary that we can't go in public, we can't see family members, we can't see our loved ones who are dying in a hospital by themselves, all alone, if it's so scary that we can't do that, why should we be spending time fighting about the Second Amendment in the Michigan State Legislature? Let's get our priorities straight. All of you can do this. All of you can tell even just one person. And then maybe then you'll tell another person. And you might then tell another. But even if you tell the one, then they would tell one. And they might tell another one. Tell someone. Tell someone what Article 3, Section 2 of our state constitution says. Michigan, I think it's michigan.gov/legislature. Is that what it is? Anyway, Google Michigan Legislature. And when you go to the Michigan Legislature website, you could see, I believe on that main webpage, it's going to be over on a left side menu, closer towards the bottom, and it'll say Michigan Constitution. And you can click through all the provisions of our Constitution, and that is the most accurate version of the Constitution. Most up to date, because there were changes made in December 2018 after the ballot initiatives were passed. So look at that Constitution. If you have any questions about it, please don't hesitate to ask. Read the U.S. Constitution. Read Article 4, Section 4. Guarantees us a Republican form of government. Read the preamble to the Michigan Constitution. Read the preamble to the United States Constitution. Read them all the way through, but focus on those ones. Focus on the words, every single word of the First Amendment, where our rights are to be exercised unabridged, or not abridged, I think is the wording, but that means unabridged. Or if you look at the wording of the preamble of the Michigan Constitution, our blessings of freedom and of liberty are supposed to be exercised undiminished by the very wording of the Constitution. Like literally, that is why we drafted and created the Michigan Constitution, is to secure the blessings of liberty undiminished for ourselves and our children. You can do this. And I'm here to answer questions. But I seriously don't have the time or the patience anymore. If people want to just pick a fight with me, bring it. Bring an actual fight. Bring an actual statute, an actual constitutional provision. Bring something of substance. Don't sit there and stick your tongue out at me and say, nana, nana, boo, boo, you're awful and you're conservative. Tell me how you think I'm actually doing something wrong. And I'm going to listen to you. Absolutely. But I just simply will not take the time to just banter back and forth. Like that time is long gone. Any questions that you have, though, seriously, in all seriousness, whether you believe in what I'm saying or you don't, whether you are a staunch Republican or a staunch Democrat, whether you are a Joe Biden fan or a Trump fan, I could care less. If you have a question about the Constitution, if you have looked at some of these laws, you've looked at MCL 8.8, you've looked at MCL 10.31, you've looked at MCL 30.403, you've looked at MCL 30.421, and you have a question about it, let me know, and I will answer it. And if I get enough questions about those kinds of provisions, I might just do another Facebook Live specifically about those. Please don't hesitate. I will answer them. Are we good? Do we have any other questions?
We're good.
Thank you so much, guys, for asking the questions. Thank you so much for tuning in and for listening and for sharing this information. I will continue to update you as I have more information, and I will put together all of these laws that I'm talking about all in one cohesive place at some point very soon. But it does take a lot of time, a lot of hours, and as I keep saying, I'm only one person. So I'm just doing the best I can to work as fast as I can to answer each and every one of your questions and to make sure you have the knowledge to be able to secure your rights and the rights of your children. Thanks, guys.